So, Hadley, the subtitle of one of your chapters from your 2023 book, Mere Natural Law, was After Dobbs, the Natural Law Moment. Now, others have picked up on this construction, natural law moment, in recent years, confirming that we're undergoing something like a vibrant renewal of interest in the first principles that animate and underlie American constitutionalism. But what did you mean when you said that we were amidst a natural law moment after Dobbs in 2022? And how are we still in it today?
Well, I think what this reflects is a growing sense we're hearing among young lawyers and judges about something missing. There's a moral coherence that is missing in our law right now, and that sense of crisis was sharpened in the Dobbs case on abortion several years ago, where the court overturned Roe versus Wade, but never quite explained that what this whole thing was about, this surgery called abortion. What is it? What does it involve? That involves the killing of a small human being. The court could overturn Roe versus Wade, but without ever saying anything to affirm the human standing of that nascent life in the womb. 50 years ago, the lawyers from Texas and Roe versus Wade offered an elegant brief drawing on the most updated findings of embryology at the time to put before the court this point that nascent life in the womb has never been anything other than a human life from its very first moments, and never merely a part of the mother. The dissenters in Roe versus Wade, Byron White and William Rehnquist, never drew on that substantive material woven with principled reasoning. And 50 years later, the six conservative judges in Dobbs, overturning Roe, never drew upon it, so they could overturn Roe without explaining that what's engaged in these surgeries is the killing of a small, innocent human being. And the telling sign there was Justice Kavanaugh in the concurring opinion saying, this is a, we're very divided in opinion in this country. Could you believe it that some pro-lifers actually believe that the fetus is a human being? Believe it, as though we have no long record of embryology reflected in all the leading textbooks on embryology, on the beginning of human life. So what Kavanaugh was telling us was that conservative jurisprudence, for some reason, would begin with by affecting not to know the plainest truth that bears on this question, that we cannot say what is a human being. It offers a reflection of that curious line years earlier from our dear late friend Justice Scalia, who said, "Well, the question of the human standing of that nascent life in the womb, there's no clear legal answer to that matter. It is a value judgment. Value judgment. That's a term that came into play with Nietzsche and Max Weber, as people were losing their confidence in speaking about moral truths. So things had moral value as we imputed moral value to them. Lincoln said in the crisis of his time that the question was whether that black man is or is not a human being. If he's not a human being, then anyone who is a human being may do to him what he wishes. If he is a human being, then he too would have the right to govern himself. Harry Jaffa, the late Harry Jaffa, said that question, black man is a human being, cannot be a value judgment, depending on how much value any one of us holds for treating the black man or the unborn child as a human being. The same way it makes as little sense to think about that with the human child. Now, the point is, getting back to our broader natural law, the American regime is not indifferent or agnostic on the question is what is the human being, the human person? The American regime was launched on the understanding that we know emphatically what the human person is, and the understanding, well, it was reflected in that the way the argument ran at the time, that no man is by nature the rule of other men, in the way that God is by nature the rule of men. Men are by nature the rule of dogs and horses. As Locke said, we cannot treat human beings as though they were made for our service, as the inferior ranks of creatures are made for ours. No man is by nature the rule of other men, in the way that men are by nature the rule of than horses. And if there exists this, if some men are in a position of ruling other men, that situation must not arise from nature. It must arise from consent. Leo XIII, in his marvelous piece, encyclical on human liberty, said, we cannot impute property rights to animals because animals cannot impart a moral purpose to an inanimate matter. Only moral agents, beings who can reason about matters of right and wrong, of the just and unjust, can be the bearers of those rights. And of course, he thought those creatures of reason were part of the same creation that the Declaration of Independence referred to. It began with that we're uh, those creatures who were invested with these unalienable rights. Those creatures, those rational creatures, were part of the order of nature, along with the laws of nature and the laws of reason. But so what we're seeing now, though, with Kavanaugh, crisis in conservative jurisprudence, is like a version of conservative jurisprudence that cannot that cannot be confident that we can speak about what the human person is, the human being is, that forms really the ground of this regime and our laws. And in fact, as Kavanaugh declares, this Constitution must be neutral on the question of what is a human being and the question of abortion. Now, if we understand those deep principles on which the Constitution was founded on, but the nature of the human person, and the kinds of justifications that we must bring forth to justify the taking of a human life, it's simply not plausible that the principles of the American founding make the Constitution neutral on the question of whether the Constitution licenses the killing of small, innocent human beings on a massive scale. So I'm afraid that what we're having here, the crisis of coherence, that I say may offer a sharper moment, this natural law moment, is with Kavanaugh and a version of conservative jurisprudence spiraling out of the connection, the thread that connects it back to the anchoring moral premises of the American political order. That we cannot speak to the question of what is a human being, and the Constitution is sort of neutral on the question of what is a human being, and the question of taking human life. Now, of course, we didn't bring this out just a few years ago with my book Mere Natural Law. This has been going on for a long time. I've been in this field for a long while, as the Bible says, arguing day in and day out. And my dear friend Jerry Bradley has been in just about as long as I have. I've known Jerry since the early 90s. On all the scholars working, I don't think anyone has been closer to me and exceeding me, may I say, in 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 the quality of his work, in piercing, persisting, insisting on moving to the anchoring moral grounds of this regime, and seeking that a kind of a jurisprudence that can give a morally coherent account of itself. There's no better partner for me in this project than Jerry, and I'm just so honored to be with him in this project together.
So, Jerry, your indispensable law review article from 2021 was titled Moral Truth in and Constitutional Conservatism. And your article speaks to this natural law moment that we're in as well. What have you observed that's unique about this moment in relation to the dominant form of constitutional inquiry on the right, original public meaning originalism, that's on vogue at the present?
Well, first I should say how delighted I am to be and having already joined my revered friend Hadley Arkes in the work of the James Wilson Institute, joining forces with Hadley and you, Garrett, and the others concerned, and working with the resources provided by our benefactors gives us all a chance to talk about what, in fact, I've explored with my own constitutional law students for now 40 years. Most recently, the last 12 or 13 years in a survey class on constitutional civil liberties, and that is to explore the moral foundations of constitutional law, constitutional reasoning, looking particularly at Supreme Court decisions. I think that the strategy, or if not the strategy, the discernible direction of conservative constitutionalism has, as Hadley described it quite rightly, uh, adopted a stance of a striking moral neutrality in constitutional cases, even involving such morally laden questions as abortion, marriage, transgenderism, free speech, obscenity, privacy, sex discrimination, you name it. So the court is deciding these cases and reaching results that are often the correct results in my judgment, but almost invariably saying of their own reasoning that they do not, repeat, do not depend upon any controversial moral or metaphysical premise. Now, when I teach these decisions in those areas, including religious liberty and to some extent privacy and search and seizure, I work through the cases and walk through the legal doctrines with my own students in survey classes and in seminars. And as we walk through the doctrine, we eventually all recognize that the reasoning of the court, in the end, or in some essential way, depends upon a supposition, a premise, which premise is not embedded in legal reasoning. It's not even something that can be drawn reliably from history, but there's a normative premise or two or more. And it's often enough suppressed or denied or ignored, but that doesn't change the fact that the court's decision in so many cases, in fact, that is in truth, depends upon some moral norm or moral truth. So I, for myself, and I'm sure Hadley would agree with me on this, none of us is suggesting that in some way, some imaginable way, natural law or philosophical reasoning should somehow supplant legal reasoning. It is rather, the position is that legal reasoning, especially in constitutional cases, is never going to be complete without conscious reliance upon a best understanding of some moral metaphysical premise or some truth of natural justice. So to think that we could decide, or anyone could decide, about same-sex marriage without having a critically justified account of what marriage is, I think is ridiculous. Similarly, as Hadley says today and elsewhere, in abortion, the Supreme Court in the Dobbs case said of its own reasoning that it was not relying upon any estimate of its own of the value of the fetus, or even of what the majority at a couple of points called potential life. And I think that's just false. That the majority's reasoning, their holding in Dobbs, uh, is incoherent or at least unconvincing, unless you suppose that the majority recognizes and depends upon the truth that abortion kills a living, whole, unborn human individual. And without that premise, I don't think the majority opinion works. So I don't think, in any event, the Supreme Court's description of what it is doing in any case
Right.
at all,
Right.
should preclude us or convince us even that there are no moral premises at work. And it shouldn't preclude us from investigating those moral foundations. And that, I'm afraid, I'm sorry to say, is what's missing in so much of legal education today. And one of the things that the James Wilson Institute does is explore with law students, recent law graduates, what's missing in their legal education, which is precisely the natural law, moral foundations of constitutional law.
Uh, Garrett, let me pick up on the line of Jerry's. We said we're not saying that the natural law supplants the positive law, because the natural law must convert itself into the positive law. When people ask, "What is the natural law?" we say, "Well, it's the law that underlies the positive law that tells us why we'd be justified in having a positive law." I used to say, you look at those signs on the highway, 35, 65 mph. There's no moral significance in those signs. But Immanuel Kant would say, um, we begin before we have those regulations of the positive law. We begin with an understanding of why we justify in restraining the freedom of people to drive at speeds that put innocent hazard. And the task is ever is to make a translation of that principle and to apply it to the terms and the circumstances of the terrain before us. 35 miles an hour on that winding country road, 65 on the open highway. Now, you mentioned, part of the crisis in my book, Mere Natural Law. I was trying to recall a ground of the natural law. Someone, great Thomas Reed, who was invoked by James Wilson in Chisholm versus Georgia, first in the opening lines of that first opinion in the U.S. reports. Thomas Reed, who's read by Jefferson and Adams, in his teachings on common sense philosophy, on those precepts of common sense that the ordinary man must be able to know before he starts trafficking in theories. And so, as Reed would point out, before the ordinary man would banter with David Hume about the meaning of causation, he knew his own active power to cause his own acts to happen. And so, as we would say, what the ordinary man would understand is that truly first principle of all moral and legal judgment, that makes absolutely no sense to cast judgments of blame or praise on people for things that they were powerless to affect. As Reed said, there's no axiom in Euclid more certain than this. Well, the understanding was, as Wilson's understanding was, we could begin with those axioms of reason that the common man grasps along with anyone else. In fact, not only grasps these things, but has to grasp them in getting on with the business of life. He has to assume that any effect must have had a cause. And and so the understanding here was that we could build, there's a natural law that is built on premises, understood by ordinary people, did not require a high dose of theory. Jefferson once remarked in a letter to Peter Carr, you could give the same question to a plowman or professor, and the plowman is apt to get it right because he will not be distracted by rules. You might say theories. The lawyers are well supplied with theories in our age. And so what I was trying to do in that book was bring us back to a ground of recognizing those precepts of common sense that had to be in place for ordinary people before going on with theories. And what Wilson was arguing, along with Alexander Hamilton, is that everything we know begins with these anchoring premises, as Hamilton said in Federalist 31. We begin with those primary truths upon which all subsequent reasonings must depend. Now, Wilson and Hamilton argued everything we know must begin in this way. With things, we move from things reliably known to the things we're trying to know. And the understanding is that you could indeed build a jurisprudence built upon premises of that kind. So what we're saying is that those principles were there before the Constitution. We're talking about a generation of founders who were able to make their way to those principles, like you don't hold people blameworthy for acts they were powerless to effect. It makes no sense to cast judgments of praise or blame. It makes no sense to hold people punishable for something that was not wrong at the time it was done. You had founders who understood there was a world of law before we sat down to frame this Constitution. They understood that there were principles there that were before the Constitution, and there would be there even if there were no Constitution. Just as John Quincy Adams said, that right to petition the government is simply implicit in the understanding of a free society. It would be there even if it hadn't been mentioned in the First Amendment. You'd be there even if there were no First Amendment. You'd be there even if there were no Constitution. So what we're trying to do in this scheme is to bring people back to those principles that have to be. That were there before the Constitution, would be there after the Constitution. I recalled at one of my talks, a talk I gave 20 years ago at Fordham about my book, Natural Rights and Right to Choose. And at dinner, the dean at the time said, there wasn't much discussion among explicit discussion about natural justice in those first years of the Republic. To which my late dear friend Dan Robinson said, yeah, there wasn't much discussion of the alphabet either. It's just woven into everything they do. And that's what Jeremy and I are trying to point out again. It is so woven into what we are doing. The moral reasoning that's so woven into it is so there, so woven in that you may no longer notice that you're doing it.
The main reason that both of you have such enthusiasm to be starting this type of podcast is that we have these kinds of discussions regularly in our seminars, but our
Right.
seminars are really tight knit. They're small. Our seminars can sometimes be as small as 12 to 15, no larger than maybe 25 or at the absolute, largest 30. But we can feel a palpable interest from the participants in these seminars, law students, young lawyers, judges, scholars, that we are providing something that's missing from our constitutional discourse. Jerry, what excites you most about this moment and being able to pull oars with Hadley?
Well, there are two parts to the moment, two elements to the present time, really a time of crisis. And they have to do with one, the nature of the issues presented to the Supreme Court and the Supreme Court's willingness to decide them. I mean, who would have thought even 10 years ago, much less 250 years ago, that the Supreme Court would be deciding this term and next cases that have to do with whether or not it's true that we are our bodies. What's the metaphysical truth about the connection between mind, spirit, and body? These are the transgender cases. And the Trump executive orders, the several of them about transgender matters, are going to press down upon the court over the next probably 2 or 3 years. So the court's going to be in a season of having to resolve questions that in the end depend upon who we are. And I don't think the founders had much articulate expression or much to share in their positive laws about whether we are our bodies. So the issues that are upon us are as vital or important to our well-being and to the common good as perhaps they have ever been. And the philosophical depth and rigor required to understand and to master those issues is probably greater than ever. So that's one part of it. The need, the other part of it is the demand, you might say, of law students and young lawyers, teaching both the students we assemble at our seminars in the DC area twice a year, but maybe especially or more especially the students that we encounter on the law school campuses. The James Wilson Institute conducts at the present moment 6 seminars abroad every year, abroad being at law school campuses throughout the country. And at those seminars, conducted over a weekend, 20 or so students will present themselves for a course of instruction and discussion. And the seminars sound, you might say, like uh, this podcast sounds. And when we're done, and these are students who are in their second and third years of law school, many of them say in these words, I didn't think anybody talked like this anymore. Or more
Right.
pregnantly, the students report, nobody says, none of my teachers told us anything about this. So the demand for a legal education with moral foundations, I think, is great. It's still yet largely inarticulate, but it is felt before it's articulated. And the feeling is widespread that there's a lack of proper moral depth to legal education generally, but I think especially in constitutional law. And we're not, Hadley and I and the James Wilson Institute and Garrett, we're not the only ones stepping into this breach. Uh, and there are others, of course, but there aren't that many and there aren't enough. So the more that we can do, the better.
Well, you asked the question, Jared, about pulling gauze. What's the pleasure of it? You've just heard what the pleasure of it is. We did another session listening to Jerry. We did a session on the Socratic case where I would come out, I laid out a line of argument, and then Jerry would give this gorgeous exposition of the fuller argument. So for me, it really is a chance for me to listen to Jerry, and I find just great pleasure in listening to Jerry expound. No one does it better. Our friend David Forty said, I don't think anyone reads cases as closely with the kind of acuteness that Jerry reads these cases. Um, as Jerry said, we have these students telling us things like that week we had together was the best week of my life. It's a trans. I have a conservative skepticism when you hear lines of that kind. I say, well, really, what got to you? And we I think it could be the first session of what we do throughout. When we did that first session, Aristotle, the opening page of Aristotle's Politics, along with the Lincoln Douglas debates, where Lincoln was really drawing out the moral logic of Aristotle's argument. Well, the first time we did this I think I told Jerry that I apologize for the students for giving what I thought would be a refresher course. It turned out it wasn't a refresher course. As Jerry said, they never heard it. They never heard it either in college or in law school. And in the opening there, I recall asking lawyers over the years, what's the rationale for the law? And lawyers would say, move along two lines. We need the law for protecting our lives and property. We need the law for making possible a more interesting economic life of contracts and exchange that would soften the rigors of life and lifting the standard of reasoning. And what comes as a surprise to lawyers still is that Aristotle anticipated both those lines of argument 1600 years ago and rejected them. That if that's the reason you're bringing forth law, guess what? You don't need law for either one of them. And what it does is clearing away those distractions, leading us back to the inescapable, what turns out to be the pervasive moral logic of the law. And the other one I just found out again in a letter from a student this last week. We do a session on the underlying moral structure of the law. We did a case where the judges are whole in agreement about the outcome of the case, but we tear each other apart over the clause of the Constitution that's doing the work. And what comes as a surprise is that the underlying moral structure of the argument is the same in all cases, but the judges are not noticing it. Once you're clear on what the underlying structure of the moral argument is, that argument could lead to be redeployed to fit a number of other cases. So again, it's piercing to that underlying logic. And again, no one has been more insistent on doing this over the years than Jerry.
I'll note that some of the citations, Hadley, that you were making in your comments just now are to the subjects of the seminars that we host, not only in the summer and the winter for a
Right.
select group of young lawyers, law clerks, and law students that we handpick from. Unfortunately, just far too many qualified applicants than we can take at any one moment. But they're also the basis for our shorter weekend seminars that we do on the law school campuses. And perhaps, if I may, I'll point to how in our early years of doing these seminars on law school campuses in 2018, 2019, we would have to do a lot of work to coordinate and convince the students on these campuses that they should spend 2 days over the weekend with the James Wilson Institute learning about this. However, since we've been doing these seminars after the pandemic receded in 2022 and onward, the demand has exploded for these. We have at this current moment 12 schools asking the Institute to visit them. And even though we've increased the number of these seminars we do every year from 2 to 6, the demand still outstrips our ability to supply them.
Well,
We're in the enviable position now.
you and Jerry were just at Yale, weren't you? You were at Yale,
No,
right?
no, Jerry and I were at Duke and UNC. You and I were at Yale, and
Oh,
Jerry
Jerry's in Harvard. Jerry's in Harvard.
and one of our alumni, Brad
Yeah,
Ribeiro,
yeah,
actually
that's right.
led a
Absolutely.
seminar at BYU. We had an extremely busy month of
Yeah,
February, but
Jerry was at Harvard and BYU. Yeah, right, right. Yeah,
the I think the difference between then and now is not just because our institute has grown and matured. I think the demand is palpable and
yeah.
growing because of this abiding natural law moment that we're in. And maybe, Jerry, can you speak to your experience and what you've seen, on these campus visits?
Well, yeah, I think that the way you describe the students' reactions to what we do is exactly right. Their eyes are opened. It's as if the first state or feeling they have is that what we talk about confirms their suspicions that they have had, that they're not getting the whole story from their professors. And then the second thing I think they experience is a kind of relief to learn that there's a disciplined, rigorous, and edifying, satisfying way in which they can investigate the moral foundations of law. I think that relief includes the relief to learn or be around people who hold that thinking critically about natural justice or thinking critically about human flourishing or thinking critically about metaphysics. And metaphysics is a fancy way of talking about, well, it would include questions such as, are we our bodies? And when do people begin? Those are really questions about metaphysics. But they learn that you can investigate those matters in a disciplined and critical way. And that divorces the student, alienates the student from the ambient relativism and even skepticism that they pick up around, I'm sorry to say, but evidently,
Right.
their law school classes. There's a kind of lazy skepticism, relativism that works as an off switch for critical moral inquiry. That's when a question comes up about whether what is marriage or when people begin, uh, they hear probably first thing, maybe from their professors, or if not from their professors, their classmates. Well, there's a lot of different opinions about that. Who's to say? Well, there may be a lot of different opinions about that. I'm not sure what it means to ask who is to say. I know that each one of us has an obligation to investigate the truth of matters of that sort. And judges are not exempt from that obligation. I mean, it seems to be the prevalent view. I think it's the view of conservatives as much as anyone else, maybe more so of conservatives, that the way ideally to be a judge is to be morally neutral, to have no horse in the race on these questions. As if a judge could decide cases, including constitutional cases, without really knowing anything much about human flourishing, the common good, natural rights, and natural justice. But I think that's dramatically mistaken. Um, it's not the case at all. I think actually judges need to know as much about those fundamental matters, moral matters, as legislators or presidents or anyone else. And they need to have that knowledge, well grounded, critically justified um, truths at hand. Now, what is also true is that judges, at least in our system, are going to bring that truth, that true knowledge of human flourishing, the common good, natural rights, and human well being, you might say, they're going to bring those truths to bear more episodically and in a more partial way, and in a way that's, you might say, conditioned by legal reasoning, than would be the case with a legislator. But they are relevant truths nonetheless. And there are certainly more than a few occasions when the job of a judge in a given case, humbly described as resolving a case or controversy using Article 3 judicial power. Sometimes the legal issue is transparent for some moral issue. I mean, legal reasoning is surely a form of moral reasoning, although a particular stylized form of moral reasoning. But there are plenty of critical matters in our constitutional law where the legal question is transparent. I use the word is transparent for the truth of the moral matter. Take the example that came up most recently in Supreme Court argument in the Catholic Charities case from Wisconsin, an case just argued earlier this spring. The lawyers were working through with the justices the legal algorithms, and they finally come up against the following question: well, what really is religion anyway? And I think the instinct of those present parties to that conversation was to say, well, we're not going to investigate that question philosophically. Well, I think the answer is yes. You're going to have to investigate that question philosophically. If you don't like the word philosophy and judge in the same sentence, and I think many conservatives don't like the word philosophy in the same sentence with judge, fine, use a different word, not for judge, but for philosophy. Say that to decide a free exercise of religion case, you may eventually have to arrive at what you think, what one thinks is the best understanding of what religion is, what it includes, what it excludes. And I think that that's an inescapable part of reasoning in many of church state cases. And it doesn't have to be called a philosophy of religion. It could just be an answer to the question, well, what really is religion?
The Jerry reminds me of something that years ago I found that my students who went to the University of Chicago would find, here's a moment. I found a group of people with whom I could actually speak seriously without looking over my shoulder to be disarming. But what we found now is, as Jerry says, is that even in conservative circles with these law schools, people don't speak in this way. They're to speak about insisting on their really anchoring truths that are central to this whole thing. And I think what they find, as Jerry says, that they're in a circle which they don't have to be apologetic about that. They have people who share their concerns, but who can have serious questions. They can argue among themselves. You could carry on this argument without being wounding. And so it becomes a refreshing experience for them. It is something quite novel for them. I think Jerry caught the real core of it.
And I think the students that we teach at the law school campuses and the ones who come to our seminars are refugees from what I think, not at Notre Dame, by the way, but at most other law schools, is a
Right, right.
suffocating classroom atmosphere. Now, frankly, I don't fault their professors very much, although maybe some professors no doubt deserve to be blamed. But I think what's suffocating is that the conservative, or let's say traditional, the moral minded student, the one who wants to talk about matters such as who we are, what's good for us, when do people begin, what about sexual morality, any number of questions. The ones who want to talk about those matters in a candid way that gets to foundations, I think, as far as I can tell, on most law school campuses, feel as if they cannot speak up. And again, not necessarily, and probably not most often, because of the reaction they fear
Right.
could be forthcoming from their professor. It's the other students. I think in this age of social media, Instagram, texting, whatever it is people do, uh, I have heard many students say over the last few years, the age of social media, that again, leave aside what particular issue is, but this would be a student at another law school, not Notre Dame, by the way, saying, "Well, I wanted to say something about the marriage case, Obergefell, or I had something to say about Dobbs, but I knew that before I even left the classroom, it would be all over the student body because someone would out me, so to speak, on social media, and that
Ah,
this let's call him conservative student speaker, would be ostracized or marginalized,
wow,
criticized by other students who weren't even present. So I think
wow.
that social media enhances and magnifies. I don't know if it's a natural intolerance these days of most law students, But whether it's natural or cultivated, I think most law students, I think partly because they're poorly educated, are intolerant of what are in fact engaging in reasonable alternative positions, but which they regard as threats or unsafe opinions. But with social media, I think it's really suppressing freedom of thought and expression, especially
Oh,
expression,
wow.
on the part of right leaning law students. And when they come to us, it's as if they've been liberated from a concentration camp.
So, Jerry, that actually happened at Notre Dame? That
At
actually
Notre
happened?
Dame, we don't have that problem, or at least we don't have that problem in anywhere near the proportions that they have elsewhere. But at other law
Wow.
schools,
Wow.
I have heard from those law students, the conservative leaning law students that come to our seminars, or we go to them, or even maybe come to a lecture of mine uh, that's not necessarily not connected to James Wilson. That's a common report that the other students, combined with social media, uh, suppress free speech in the classroom.
This reminds me of a story, Jerry, I heard only last week from a dear student of mine who was at Vanderbilt about 20 years ago. And in the course on constitutional interpretation, he raised the question with the professor about isn't there a possible way of reasoning through these matters morally, through this moral reasoning? And the professor, oh, you mean some kind of natural law? And he said, when students ask me that, I asked them, where did you go for your undergraduate education? Where did you go to college? He said, Amherst. Oh, you probably worked with Hadley Arkes. And okay, but the critical point here was that another student listening to this raised the question, saying, "Are there other places where this people say these things?" And the professor, oh yes, there's Robbie George at Princeton, and it came as uh, a matter of wonderment. So much that the student had to ask a question: are things ever discussed in this vein in other places?
Yeah, yeah. It's just a matter. It's not a matter of, I don't know. Well, some might call it indoctrination, but it's not a matter of turning a law school class into a philosophy class or anything of the sort. It's
Right.
actually just a matter of being a good law school class in which you can get to the bottom of something and express yourself freely and without fear of retaliation. That's what I call education. And given that we're talking about the things we're talking about, that's what I call legal education. And I'm sorry to say that I think most law schools do a very bad job of delivering legal education.
When people listen to Jerry, the reaction is, "Well, of course. Now, why didn't I think of that?" You know, that makes so much sense. A question arose. I don't know if we have a couple minutes for this one, Garrett. There's some ordinary cases. A question rose from one of our friends among the judges. Can you recall places in which the court actually appealed to the natural law in making a judgment on cases? And say, yes. Are you asking me whether we have instances in which real judges made an appeal to those principles that were there before the Constitution and would be there even there? Yes, we can show you how Marshall did it, James Wilson, other people did it. Yeah, it's been done. I'd say showing how that was done, that's our us. That's what we do here. But what came out to me is just how these things were shown in the cases that otherwise don't seem to us be uh, critically important cases. There's my Jerry knows one of my favorite jurists is the late Robert Jackson. In that case called Irvine versus California from 1954, the feds were after a bookie, and going after him, they entered his house several times to readjust the microphones and listening devices. And Robert Jackson said this was not only an intrusion, it's probably also a burglary. But then he said he said but he wasn't going to use the exclusionary rule. He doesn't want to throw out the evidence about the wrongdoing because he said it does nothing to punish the wrongdoer, the police, and it doesn't do anything to deal with the lawbreaker. He said we don't free one lawbreaker because he happened to be chased by another. Okay, we don't free one burglar because he was chased by another. That's an innocent comment, but in its own way, it's a reflection of James Wilson years ago arguing against Blackstone, where Blackstone said we can't incorporate in the law a principle of revolution because revolutions unsettle things. Laws settle things. Revolutions unsettle. But Wilson says, yes, the American law can begin with the recognition of a principle of revolution because the American law begins with the notion that you can have an unjust law, that something can be passed with all the trappings of legality, but we have access to a body of principles outside the positive law that were there before the positive law, by which we could gauge and deliberate about the quality of the positive law. And what Robert Jackson was telling us in his own way, yeah, that's what's going on. The fact that these people were acting under the color of law does not bar us from pronouncing them burglars. The fact that they were acting under the color of law did not mean we were bereft of the grounds of judging them. In other words, he's assuming once again that we do have access to those principles of the natural law that the founders not think important, could not think it conceivable to set down in all the text of the Constitution, but they were there, and he simply assumes that they were there, and we understand what he's saying because we share the assumption, and we're not noticing it because we might say it is just so natural, so natural.
So I think for our listeners, you've just been given a little sample of what we have in store for this podcast. We'll be releasing episodes every other week, and we hope that the episodes will cover not only the timeless subjects that indeed we do cover in our James Wilson seminars, but also some topics that may arise in the course of our American legal and political life. Hadley and Jerry are well known to audiences in their ability to weave in discussions of natural law to the cases that come before the Supreme Court, to the proposed legislation before the Congress, as well as the executive's ability to enforce the law. And so we're just absolutely delighted to be bringing you this new series from the James Wilson Institute, The Natural Law Moment, and we hope you'll join us. And to our two co-directors, Hadley Arkes and Jerry Bradley, we cannot thank you enough for providing us that light that so many of our students tell us that they fumble in the dark until they find it. We hope you
Okay,
listeners
but
enjoy
they're,
this.
Garrett, what I point out, what they're going to see is me feeding Jerry straight lines or feeding lines of argument, and then
Yeah.
they can sit back and listen to Jerry expound the law. And this is I can't get enough of it. I love to listen to him, and I think that's what we can look forward to.